Dear friends of arbitration, we are back again. Our guest today is Sacha Willaume. Sacha is admitted to the Paris Bar in 2011. He specializes in international arbitration and dispute resolution. He has acted in arbitrations as counsel or secretary in international, ad hoc, and institutional arbitration proceedings. Such institutions as ICC, ICSID, SIAC, CCIG, CPA. His focus areas include energy, joint ventures, distribution, intellectual property, and construction. He also has experience before French court proceedings related to arbitration. Sacha holds his LLM from King's College London and his master's from University of Paris I and Columbia Law School. He is one of the featured arbitration leaders. Sacha is going to explain to us in a moment recent developments under French law. Sacha, floor is yours.
Good afternoon, everyone. Well, first of all, let me thank you, Dr. Yeşilırmak and Dr. Pafari for giving me this opportunity to make this presentation in the course of this webinar on arbitration law in France. This is a great honor to be here today, and perhaps I should start with a few words on myself. I'm Sacha Willaume. As Dr. Yeşilırmak mentioned, I am part of the international arbitration team at Gide in Paris, where I practice in arbitration, commercial, and investment. So today, I have the pleasure of addressing you on recent developments in French arbitration law. There are many hot topics at the moment, so I've chosen to focus on an angle that might be of interest to you as foreign practitioners, which is the recognition and enforcement of international awards in France. In the limited time that I have, I will try to give you a brief overview of some of the relevant issues that have arisen in the course of last year and more generally over the past few years. But before discussing several cases and those grounds for recognition, non-recognition, or challenge of arbitral awards, I think it is important perhaps to give you a bit of context on how you can enforce or challenge an award in France from a procedural point of view. So in terms of, you could turn to the next slide, please, and the one after that, and the one after that. Thank you. So basically, there are two situations when you are receiving an award, a foreign award. Either you are the winning party or the losing party. If you are the winning party and you wish to enforce the award in France, you need to have what we call exequatur, which is basically a way of turning your award into the equivalent of a court decision. And this is, of course, a necessary step before you can try to seize assets from the debtor. This is a rather simple process. It is an ex parte application before Paris Court of First Instance in the case of international arbitration. And the court will usually grant the exequatur if you can demonstrate that it is not manifestly contrary to international public policy. This is very, very rare not to obtain the exequatur. You have basically to present the award or a translation thereof if needed, and usually you get a stamp for enforcement. If you are the losing party, however, the things are a bit different. If the award was made abroad, then you can appeal the exequatur order before the Paris Court of Appeal. You have a very specific time period to do so. You have basically 1 month to appeal from the moment you receive the notification of the executive order, plus 2 months if you are domiciled abroad, so in total 3 months. If the award was made in France, the normal way forward to challenge the award is what we call a recours en annulation. It is an application to set aside the award before also the Paris Court of Appeal. And I should mention here that there is an interesting element in French arbitration law, which I believe is also the case in Turkish law, which is that parties may opt out of the right to apply to set aside the award. This is a possibility, but in practice, it remains quite rare for parties to do so. So what type of decision can you seek to challenge in France? And that's the difference perhaps with some other countries. You can only challenge an award and not a procedural order. So that's an important element also when you submit your claims in the context of the arbitration. This is the point to bear in mind if the award will be rendered in France. Another element, perhaps, in terms of procedure, before moving to the substance of the grounds, is that since 2011, where a major reform in French arbitration law took place, in international arbitration, enforcement is not suspended unless the judge orders a suspension, which is quite rare. So the principle is really that even if a challenge is ongoing, you can enforce the award until such award is annulled, as the case may be. The only case where a suspension of the enforcement can be obtained is if you can demonstrate that the enforcement would severely prejudice the rights of one of the parties. So, next slide, please. And the one after that. So the application to set aside, I've set out some basic requirements as I was mentioning. So you can move to the next slide. So I now move to the grounds, i.e. the substance for refusing or to enforce an arbitral award in France. So next slide, please. I've perhaps a few introductory remarks. It is important to understand that the purpose of a challenge in France is really not to redo the match. It is not a reconsideration of the merits of the law. You can only challenge an award, whether by way of recours en annulation or by way of appealing an enforcement order, on 5 limited grounds, which are the same, whatever the type of recourse which is being pursued. Those 5 grounds are set out in Article 1520 of the French Code of Civil Procedure, which I have reproduced on the slide, which states that an award may only be set aside where, first, the arbitral tribunal wrongfully upheld or declined jurisdiction. This is a classical jurisdiction challenge. Or second possible ground, the arbitral tribunal was not properly constituted. We will come back to that. Or third ground, the arbitral tribunal ruled without complying with the mandate conferred upon it. Or fourth ground, due process was violated. And finally, the 5th ground, the recognition or the enforcement of the award would be contrary to international public policy. Before entering into the details of each of these grounds, I should make 2 remarks. The first one is that, as you may know, France is a party to the 1958 New York Convention on the recognition and enforcement of arbitral awards. However, in practice, this convention is almost never applied. Why? Because, as you may know, Article 7.1 of the New York Convention allows for a more favorable law at domestic level to apply if it exists. If you can demonstrate that your domestic arbitration law is more favorable than the New York Convention, then the domestic law will prevail. And it is the case in France. And the classic illustration of this pro-arbitration approach is notably the fact that in France, you can enforce an award that has been annulled at the seat of arbitration. To take a simple example, if you have an award which is rendered in Istanbul, if it is annulled in Istanbul, you can still try to obtain its enforcement in France, provided, of course, that none of the 5 grounds which I've just mentioned are present. So this is quite an isolated approach, I would say, compared to many other countries. But France is actually not the only country to do that, because in fact, for example, the US have taken a similar decision, for example, in the Pemex versus Mexico case in 2016, where they accepted to enforce an award that had been annulled in Mexico. The second remark I wanted to make at that stage is that there is a rule which I would call a rule of waiver in French arbitration law. Pursuant to Article 1466 of the French Code of Civil Procedure, a party which knowingly and without a legitimate reason fails to object to an irregularity before the arbitral tribunal in a timely manner shall be deemed to have waived its right to avail itself of such irregularity. This is an important rule because for many of the grounds which we will be discussing, if this ground has not been raised before the arbitral tribunal first, then you cannot bring it for the first time before the Paris courts. That does not apply to all the grounds, and I will come back to that. I should simply mention at that stage that, for example, if you invoke a violation of international public policy, substantive international public policy, then the court will consider that this is something that cannot be waived and that you can still bring for the first time before the Paris court. So those were 2 preliminary remarks I wanted to make, and I shall now turn to a quick review of each of these grounds. So the first ground is jurisdiction. And as I mentioned, if you intend to challenge the jurisdiction of the arbitral tribunal, you need to make that argument first before the arbitral tribunal. The extent of the control of the court is rather broad for this typical ground. So the court will really look at all the circumstances, factual and legal. They will carry out a full review of the situation to assess whether the arbitral tribunal had jurisdiction. And it really works both ways, because it will be the case if the challenge is about saying that the tribunal had no jurisdiction. But for example, I'm working on a case at the moment where the tribunal considered that it had no jurisdiction. And this is now something that we are trying to challenge before the Paris court, saying that they did have jurisdiction. So it really works both ways. So what are the type of issues which you will encounter under this ground? Those are quite classical issues. The validity of the arbitration agreement, the existence of such agreements, the issue of whether that arbitration agreement can be extended to non-signatories, or whether the dispute is arbitrable. So next slide, please. So the validity of the arbitration agreement is also a recurring issue. The only thing perhaps at this point at this stage to point out is that French courts assess the validity of an arbitration agreement not by reference to conflict of laws rules, but according to what we call substantive rules, règles matérielles of French international arbitration law. Basically, the court will look at the common intent of the parties to identify whether there is a valid arbitration agreement, and the only limitation will be international public policy. But another issue that comes quite regularly in the case law is the very existence of the arbitration agreement. And here, because sometimes parties will consider that there was no meeting of the minds, no agreement to arbitrate. And here we have a very interesting case that was rendered last year, which is called the Sultan de Sulu case, which gave rise to a decision of the Paris Court of Appeal on 6 June 2023. This is quite a complex case, so I will try to just give you some of the most salient features, but it actually takes us back into history. You had an agreement which was signed in 1878 between the Sultan of Sulu and two European individuals. Sulu was basically the sovereign of a small part of the island of Borneo, which is now split between Indonesia and Malaysia and Brunei. And basically, according to this contract, the Sultan granted some rights to these two individuals to occupy and benefit from the certain territories on the island of Borneo, and in exchange for the payment of a yearly fee. This fee was paid for a very, very long time to the successors of these people, who, of course, are now deceased. Sultan Sulu had a number of successors from his family who were now Filipino citizens, while the two explorers, their rights were transferred to the state of Malaysia. So in the end, Malaysia would continue to pay certain fees to these Filipino citizens. And until approximately, I think it was the 90s or around this time, when Malaysia stopped making those payments for a number of political reasons, which in turn led the Filipino citizens to start an arbitration against Malaysia, claiming compensation for the unpaid fees. And such compensation was quite sizable, since they were basically claiming $15 billion. The problem is that the contract was a very old contract, actually drafted in a very old version of Malay, which was very difficult to translate, but basically stated that any dispute would be settled by the British Consul General, so sort of ambassador, British ambassador, if you will. The problem is that this function no longer existed at the time of the arbitration. So the Filipino citizens finally obtained the support of the Spanish church to set up the arbitration and appoint an arbitrator who decided that he had jurisdiction over this dispute. The award on jurisdiction was challenged, was enforced in France and challenged in France, which gave rise to this very peculiar case. And here, the Paris Court of Appeal had to decide whether there was an agreement to arbitrate between those parties, bearing in mind that the disputed clause actually did not mention the word arbitration. It just mentioned dispute. It was quite unclear. But the Paris Court of Appeal found that there was a third party, and that its role was to actually settle the dispute. And therefore, they found that there was indeed an agreement to arbitrate. However, while you would expect that the Paris Court would have tried to enforce this arbitration clause, it found that the implementation of this clause had become impossible because the very function, this function of the British Consul General no longer existed, and therefore there was no way of implementing this arbitration clause. And so in the end, they considered that the arbitrator, in fact, had no jurisdiction to render the award, and therefore annulled the award and dismissed the claims. So as you can see, it's quite interesting because it shows that despite a pro-arbitration bias, in some certain cases, the court will consider that the modalities of the arbitration may be taken into account in the assessment of the consent of the parties, which is actually quite criticized because normally the idea is really that as long as you have a principle, you have an agreement as a matter of principle to arbitrate, the mere fact that the modalities are still unclear or ambiguous should not stop the parties from going to arbitration. This is sort of a peculiar decision, which I thought was worth mentioning. If you can move to the next slide, I will perhaps just say a few words about another case dealing also with the existence of the arbitration agreements, simply to say that consent to arbitration can be tacit, meaning that sometimes you can have a party exchanging, two parties exchanging, for example, their consent on the content of a contract, but not with a party that does not necessarily accept expressly the arbitration. But in this case, for example, you had a party which received an offer to conclude a contract, and in the signature block of the person that made the offer, there was a reference to arbitration, and the other party accepted the contract but said nothing about arbitration, and the court decided that the mere fact that you had the signature block referring to arbitration meant that the other party was presumed to have knowledge of this arbitration clause. And because it said nothing, did not say, okay, but I'm sorry, I do not consent to arbitration, considered that it had given its consent to arbitration passively. So this is another illustration of the pro-arbitration bias, which you can see in the approach of the French courts. So I will now move to the next slide. So I mentioned briefly that the a recurring topic is also the extension of the arbitration clause to non-signatories, but I will leave this issue aside for the moment because in the interest of time, I will move to the other grounds. Just a word perhaps on the issue of arbitrability. There are very few areas today which are considered to be non-arbitrable in France. Most disputes are arbitrable with a number of exceptions, of course, but the big issue has been about what we call subjective arbitrability, and more specifically, the arbitrability of disputes against French public entities. For a number of years, we thought that, notably in light of a very famous decision called Galakis, which was rendered in 1966, that we could arbitrate against any type of foreign or French public entity. And we have this famous rule, this famous decision, which stated that an international contract entered into for the purposes of and under the conditions conforming to the ICSID of trade can be arbitrated. So we were quite surprised to see that the Supreme Court, the Conseil d'État, which is the Supreme Administrative Court in France, actually took a reverse position last year in a Ryanair decision, where they decided that the dispute between a French public entity and a foreign party, even concerning a contract concluded for the purposes of international trade, so even in an international environment, is not arbitrable. So this is a highly criticized decision because it creates discrepancy between arbitration, which is brought against a French public entity, versus an arbitration which will be brought before a foreign public entity. And in our view, there is no real ground for making such a distinction, but it shows that there are still a number of controversies, I would say, and especially a diverging opinion between administrative courts in France and judicial courts. I will now move to the next ground, which is on the next slide. The second ground for annulling an award is in the situation where the arbitral tribunal was not properly constituted. Again, this is an argument that has to be raised before the arbitral tribunal to be admissible. So the types of issues which you will see under this ground is actually mostly around the way the arbitral tribunal was established. And one of the big issues here is, of course, independence and impartiality. We have had a lot of cases about this issue, and in particular about, as you know, the scope and extent of the disclosure that is imposed on arbitrators disclosure of possible conflicts of interest. So if you could jump to the next slide, please. We've had an interesting example last year dealing with this specific issue in the Port Autonome de Douala case, which was rendered in January last year. In this case, there was a dispute between public entity of Cameroon, Port Autonome de Douala, in relation to a concession contract which had been awarded to a company called DIT. And this dispute gave rise to an arbitration, in which the tribunal found against the public entity, and this award was challenged by the Cameroon public entity before the Paris Court of Appeal. What happened is that it was a partial award on jurisdiction, so the arbitration continued. What happened is that at this moment, when the challenge, just after the challenge was brought, the counsel for DIT was Professor Emmanuel Gaillard, a very famous authority in arbitration. Professor Gaillard suddenly passed away, and that gave rise to a lot of events in the world of arbitration, a lot of eulogies, and in particular, a eulogy that came from the president of the arbitral tribunal. And this eulogy was extremely, I would say, emphatic and showed high praise and a very close personal relationship between Professor Gaillard and the president of the arbitral tribunal, who was presented as a long-standing friend, someone who was admired, and someone who would be consulted for every important decision of the president of the tribunal. And this gave rise to a very big challenge in the context of the challenge before the Paris Court of Appeal from the Port Autonome de Douala, who said, well, here we have the demonstration of a very close personal relationship between a counsel for the opposing party, and the president of the arbitral tribunal. And this long-term close personal relationship had not been disclosed by the chairman of the tribunal. And the Paris court made a very interesting distinction here. On the one hand, it said, well, as long as it relates to a professional relationship, academic relationship, it is fine. You do not have to disclose it. It's part of, we know how it works. We are all professionals. We know each other. This is quite normal to be to interact in the professional world. However, the eulogy demonstrated a very close friendship between these two persons, and this close personal friendship was, in the mind, I mean, in the view of the Paris court, sufficiently important to create a doubt in the eyes of a reasonable party as to the independence and the impartiality of the president of the tribunal, the arbitral tribunal, and that led to an annulment of this award. So I will now move to the third round of annulments, which is the situation where the arbitral tribunal has ruled without complying with the mandate conferred upon it. This is a ground which is construed rather restrictively by French courts, i.e. it is not a way of revisiting the merits of the case. You really have only certain situations which can give rise to a challenge under this ground. The usual type of issue is, for example, ultra petita, meaning that the tribunal, for example, awards your interest while no one has claimed for interest, or perhaps a situation where a tribunal has applied a law that was not the law chosen by the parties. So you really have a few, very few situations where you can obtain the annulment of an award on this ground. And in practice, it is quite rare for the court to annul on this ground. But we do have some case law. If you come to the next slide, yes. We've had an interesting case last year about the question of the procedural rule chosen by the parties. What if the arbitral tribunal has not complied with the procedural rules chosen by the parties? For a long time, it was considered to be a valid ground for setting aside the award if you could demonstrate that that had an effect on the outcome of the arbitration. However, we've had a recent case from the French Supreme Court in April last year, in the case of Ferrovial Agrement, which actually suggests a new position of French law on this issue. And there, the French court stated that it is not for the Court of Appeal seized on the claim of non-compliance with a mission under Article 1523 of the Code of Civil Procedure to review the conformity of the procedure followed with the applicable procedural rules. So just to give you a bit of context, in this situation, the parties had chosen a Tunisian procedural law and Algerian procedural law. And under this law, the award has to be signed and dated by the arbitrators. And apparently that had not been done in this situation. But the court considered that that had no impact on the award, and therefore it refused to annul the award. So now turning to the fourth round of annulment. This is an important one. This is about due process. And it is premised on the idea that arbitrators must observe the parties' right to be heard at all stages. And here we have an interesting debate as to whether arbitrators should apply the Iura Novit Curia rule, which is frequent in certain countries. And the question here is whether an arbitrator can raise certain legal arguments on its own motion, even if they were not raised by the parties. And here we have quite a clear case flow of French law, where basically you can do so. The arbitrator can decide to raise an issue of its own motion, but it cannot do so unless it has given the parties the opportunity to discuss that issue. The idea under this ground is that the parties should not be surprised by the content of the award. The award has to be based on the evidence submitted by the parties, and if something new arises, that has something. This is something that has to be to give rise to a debate among the parties. And we have a very recent case here from March 2024 on this situation where the court annulled the award because the tribunal relied on the ICSID formulas, which is a usage of international trade. And the parties had not referred to this usage. They had referred to another usage, but the fact, the problem for the court was that the tribunal not only referred to this ICSID usage, but relied on it actually in its decision-making. And that had an impact on the decision it rendered. And that the court found that it was a violation of the process, and it annulled the award. And that leads us to the final ground for refusal of enforcement of an arbitral award in France, which is international public policy. An award that violates international public policy will be annulled in France. This is a common element which we find in a number of jurisdictions. When we talk about international public policy, we mean French international public policy, i.e. The set of values which France considers that there can be no breach of, even in international cases. So you will find, for example, under this heading, situations of fraud, bribery, corruption, money laundering, certain violations of UN embargoes, that type of things. And here we've seen a very interesting evolution of the case law over the past few years. This evolution goes towards a greater control of the French church over public policy. The previous approach, at the beginning of the around 2004, was rather minimalist. And the idea was that to claim a violation of international public policy and to obtain the annulment of the award on such ground, you have to show that the violation is clear, effective, and concrete. In fact, it meant that really it had to be extremely obvious. This approach is no longer allowed in France, and now the judge considers that it has to carry out more intensive control. And this has started in situations where allegations of corruption were made. If you could move just to the next slide, please. And we've had two very important cases rendered in 2022 on this topic, which have really sort of shifted the position of French law on this issue. The first one is the Bellocon case, in which the French Supreme Court took a very clear position in favor of an extended review by the annulment judge in cases of corruption. And that review, that's an important element, is not limited to the evidence presented before the arbitral tribunal, meaning that new elements can be brought at the annulment stage, and the annulment judge is not bound by the findings, assessments, and qualifications made by the tribunal. And there, a few months after that, another case actually came along, the Sorelec case, issued by the same Supreme Court in September 2022, where the French Supreme Court approves the Paris Court of Appeal in its decision to control the allegations of corruption by examining all the evidence produced, regardless of whether they had been previously submitted to the arbitrators. And here, the important element is that corruption was raised for the first time before the annulment judge. And this decision has given rise to a lot of criticisms, precisely because it raises issues of good faith, obviously, because it doesn't mean that someone can just reserve its argument in corruption for the annulment judge and not say anything before the arbitral tribunal. This is an ongoing debate, but at the moment, this is the situation of the law in France on this specific issue of corruption. And perhaps just to finish on this presentation, I would like to finish with a few words of the Alstom case, which has given rise to a lot of literature, because it's a truly international case with developments in a number of jurisdictions, including France. And the final episode of the Alstom case was in France, in a decision issued last year by the Versailles Court of Appeal in March 2020. So some of you may have heard about this case. I will just try to be quite brief. This is a case which concerned the conclusion of a number of consultant contracts between Alstom and a consultant, some sort of business partner, if you like, for obtaining certain important projects, railway projects in China. And several contracts were concluded between Alstom and the consultant. And until such time as 2010, when Alstom stopped making payments to the consultants. The consultant started arbitration, ICSID arbitration, to claim for the unpaid commissions. And Alstom refused, alleged that there were indicia of corruption, and that was the reason why they had stopped making those payments. The arbitral tribunal found that the evidence of corruption was not there, and therefore upheld the claim for compensation and ordered Alstom to make certain payments to this consultant. Afterwards, the consultant tried to enforce the award in a number of jurisdictions, notably in Switzerland and England, which granted enforcement to the arbitral award, and Alstom even tried to challenge the award before the Swiss federal courts, but that challenge was dismissed. However, things turned out a little different in France, because the consultant tried to enforce the award in France, and the Court of Appeal in 2019 refused to enforce the award because they considered that there were serious red flags of corruption in this case. However, there was a new development in September 2021 where the French Supreme Court overturned the Court of Appeal's decision because it considered that the Paris Court of Appeal had misinterpreted a key piece of evidence, which was the transcript of the hearing in the arbitration. And this transcript had been at the center of the decision of the Paris Court of Appeal, but it was a sort of distortion. It had been improperly interpreted by the Paris Court of Appeal, and therefore the French Supreme Court considered that because of that, the decision of the Paris Court had to be overturned, and therefore it remanded the decision to another Court of Appeal, which leads it to the Versailles Court of Appeal, which rendered this decision in March last year and decided that, unlike the Paris Court of Appeal, that indicia of corruption were not there. And therefore, we now see a sort of alignment between the decisions in all three jurisdictions. And I will stop there for a moment, and I'll be happy to answer any questions you may have on these issues. Thank you very much.
Thank you very much for your presentation, Sacha. It was very extensive and inclusive of your own evaluation. It was a great presentation. I have a couple of questions. One is about transparency. It's a problem for almost every jurisdiction. I recently published a book chapter on that, Transparency in International Commercial Arbitration. I compared the rules and see that there's no really extensive transparency rules worldwide. Is there any initiative under French law or throughout French practitioners about writing your own rules for transparency for national and international arbitration?
Thank you. That's a very interesting debate. I think at the moment, I wouldn't say that there is specifically a French initiative, but there is a lot of debate in France as to the extent of transparency, what should be the right level of transparency in arbitration. And here, I think we have a big divide between commercial and investment arbitration. I think commercial arbitration is still seen, at least in France, as inherently confidential. This, I think, is really is practice and one of the seen advantages for users. But the situation is really different in terms of investment arbitration. And I've discussed it, for example, with some clients, state and public entities who are very keen on having such transparency situation where a state is involved, because there is, of course, an element of public interest in many of the treaty disputes, for instance. And there, that's really where transparency is most located.
Yeah, but they also have interest of the parties to arbitration. For commercial arbitration, they also have interest in having disclosure of certain levels.
Absolutely, but you see, for example, the ICC now, which as you know, is based in Paris. Now the ICC has a new policy where if you do not oppose it, the award, or certain part of the award, can be made public. And this is an interesting element because I think it's also important to know how tribunals resume, how they decide, and it's quite for the academic world. I think it's quite important to have access to this material.
Sure. ICC's initiative is great, and the rules standards set by ICC is far more greater than IBA rules on this transparency or disclosure. My second question is about jurisdiction, your jurisdiction. Should we choose France as a place of arbitration? And if yes, why should we choose France as a place of arbitration?
That's always a difficult question to answer. I think the advantage of France as civil arbitration. I mean, probably not very objective because that's my home country, but I do see the advantages of choosing a civil in France for a number of reasons. The first one is that we have a very long-standing history of arbitration. We have a reformed arbitration law in 2011 to adjust to adopt a very modern approach to arbitration. I refer to the rule that whereby arbitral award can be enforced despite being annulled at the seat. This is very there is a real pro-arbitration bias. Also, for anyone who trusts arbitration, I believe that there is a real comfort in having a seat in Paris, because there you have very experienced courts, especially the Paris Court of Appeal, who are really precise in the way that they decide the cases. They're very they listen very much to the parties. They look very precisely at the issues, and they know arbitration very well. And the French Supreme Court is also made of a number of very experienced persons in that respect. And I think that the extensive control on corruption, for example, is something to be approved in the sense that this is an important issue, and I think it also goes to the legitimacy of arbitration, to be able to have judges who can really look into an award and make sure that this award is perfectly fine. I think it's important that an award can be properly screened on this type of issues. And it doesn't mean that it is an entire arbitration approach. I think it's meant to actually show that the arbitration is a reliable dispute resolution. So I think to make a long answer short, I would definitely recommend it.
Thank you. There is another question coming from our audience.
Yes.
Is it not too harsh for someone just occasionally replying an email and not realizing that he or she entered into an arbitration agreement, like in the Transgourmet case? Was the arbitration agreement written in a size big enough to be noticed clearly in the case? If you know,
that's a very fact-sensitive issue. But I agree that it invites the parties to be very vigilant, to be very careful about what they agree to. Some people could consider that it's perhaps a bit far-fetched because perhaps you didn't pay sufficient attention to that. But I think the idea is also that arbitration is considered to be the common way of resolving disputes in the commercial world. And I think the underlying idea is that that parties should not be really surprised to be bound to arbitration, because arbitration, especially in this type of disputes, which involve classic sales contract between international parties, the idea is really that arbitration is the usual way to go. And there you had a reference to arbitration rules in the signature block. But I agree that it's open for debate.
Okay, thank you very much.
Thank you very much.
This is the end of our broadcasting. We are grateful to Sacha Willaume for his great presentation. And this broadcasting is brought to you by Turkish Arbitration Academy. We are grateful our team making this happen. Thank you very much. All the best.
Thank you very much.